Ladies and gentlemen, thank you for participating in our MCLE conference call provided today by SulmeyerKupetz. Today's speakers are going to be Asa Hami and David Goodrich of SulmeyerKupetz. This seminar is going to deal with involuntary petitions, and we had intended this to be kind of a crossover program for people who do not do bankruptcy work regularly. And we've seen from the list of participants, we have several regular bankruptcy practitioners. So for those of you who understand bankruptcy law, please bear with us. Some of this stuff is very basic. There are some really good points, I think, in our presentation. So if you can hang with us through the whole presentation, we'd appreciate it. Okay. So we're going to go ahead and start with Asa. He's going to get us going in the right direction.
Good morning. Thanks for joining us. We wanted to start off first by clarifying exactly what we will be discussing during this webinar. The webinar is titled, quote, Forced into Bankruptcy, Benefits and Pitfalls of Involuntary Bankruptcy. Being, quote, forced into bankruptcy, I think could be understood in two different ways. First, it could refer to a scenario under which you have a distressed company that decides to file bankruptcy in response to pressure from actions taken by creditors. So, for example, if a lender is about to foreclose on property or a company is about to be hit with a large judgment. Whereas the company was pressured to file bankruptcy, it ultimately does so under those circumstances voluntarily and puts itself into a bankruptcy case. That scenario is still a voluntary bankruptcy case, even though the company may have been, quote, forced to file. The other way this could be understood is when creditors actually file a bankruptcy petition against the distressed company and actually puts the company into a bankruptcy case against its will and without its consent. This second scenario is a true involuntary bankruptcy case. That is the type of bankruptcy case we'll be discussing during this webinar. Excuse me. There are several distinctions between these two types of cases that are important to understand in considering whether or not to file an involuntary case against a company or an individual. For example, how the cases are commenced, the status of the entity in the bankruptcy case, and the risks creditors face in commencing an involuntary petition that are not necessarily present in a voluntary bankruptcy case. All of those types of topics will be discussed today.
Okay, so now we're going to give you a general overview of an involuntary proceeding. A lot of what you would need to know is located in 11 U.S.C. 303. Primarily, you find the eligibility requirements for under 303A, and then the process itself is defined and established under 303B, the Bankruptcy Code. An involuntary proceeding is typically a creditor's remedy, but can also be available to equity holders and partners. Partners is a unique one, and we'll discuss a little bit more about that, but it is provided under 303B3. Involuntary proceedings are only they're limited rather to Chapter 7 liquidation cases and Chapter 11 reorganization. An entity or an individual cannot be forced into a Chapter 9, Chapter 12, or Chapter 13 case, and that can be found in 303A. An entity that's put into bankruptcy involuntarily is called the alleged debtor because, as that indicates, the company itself or the individual is not technically a debtor, they're just an alleged debtor, and until there's an order for relief adjudicating them bankrupt, they will remain an alleged debtor. That period of time where the debtor remains an alleged debtor is called the gap period, and we'll discuss that in greater detail in a few minutes. Also, the filing of the bankruptcy petition in an involuntary case establishes the automatic stay, which is automatic, and there are only there's a handful of exceptions, a couple you should be aware of, and we'll discuss those a little bit later, in particular where you have an individual who has filed multiple cases within the 12-month period preceding the filing of the involuntary petition. Also, during the gap period, there is no trustee appointed under Chapter 11 or Chapter 7. The only way a trustee is appointed is if the court orders the appointment of one, and as we'll discuss in a little while, it's very important for a petitioning creditor to make a decision on whether a trustee will be brought in before you even file the involuntary petition. Also, transfers that are made in the gap period are not recoverable as a preference or fraudulent transfer, so that kind of goes back to the issue of deciding whether or not a trustee should be appointed early on in an involuntary case. And also, there are no trustee powers that are available to a debtor after, or I'm sorry, an alleged debtor after the petition is filed. Only after the order for relief is entered can the debtor or trustee enter into stipulations for relief from stay or to seek avoidance of transfers. Okay, so that's the overview of what we're going to discuss today regarding involuntary petitions. All right, so Asa, the first step is to actually initiate the involuntary case. What do you need to do?
That's right. Before getting into how the involuntary bankruptcy operates in more detail, it's important to understand how the case is commenced. Commencing an involuntary bankruptcy case is really quite simple. All it takes is essentially completing a court form that primarily identifies the name of the party against which the bankruptcy case is being filed, the names of the parties filing the petition, and the nature and amount of their claims. Although all federal courts, which includes bankruptcy courts, are on a mandatory electronic filing system throughout the country, it's important to know that an involuntary petition cannot be filed electronically. It requires filing the old-fashioned way, although it may not be old-fashioned still in state courts, by actually going down to the courthouse with a petition in hand and taking it to a filing window to get filed. At least that's the case in this district, which is the Central District of California. The petition also requires original signatures of the petitioning parties, so that means copies faxed or emailed cannot be used for the petition to be filed with the court. These are all requirements that do not exist for voluntary bankruptcy petitions. And although they may not be complicated or difficult requirements, they are important to remember from a practical perspective. Because if you're scrambling to get an involuntary petition filed by a date certain, you need to properly plan ahead as much as possible to allow time to get the original signatures, and this could be especially difficult if the petitioning parties are in different or somewhat faraway locations, and you need to make sure to get your messenger to the courthouse in time before it closes that day. These are issues that you don't have necessarily with electronic filing, where you could use copies, and you also have until midnight of the particular day to get the filing in.
It's also noteworthy that you might want to give yourself a few hours of extra time in the event that the petition is rejected at the filing desk, which could be a possibility, and you need to plan for that in the event that you need to redo the involuntary petition. It's not a very complicated document, but you should give yourself some extra time because you do need original signatures and you do need it to be actually processed by the court clerk.
That's right. So again, although these are really easy to comply with, it's just necessary to know to ensure that you properly plan for the filing. We'll next move to discuss the more substantive requirements for commencing the involuntary case. And that varies really depending on against whom you're filing the involuntary petition. So if the petition is to be filed against a corporation or an individual, it could be commenced by the creditors of the entity or the individual. And the number of creditors that must join in the petition depends on the total number of creditors that the entity or individual has. So if the entity has 12 or more creditors, the petition must be signed by at least 3 creditors, and those creditors must hold non-contingent unsecured claims that are not subject to bona fide dispute, and the claims have to be in the aggregate of at least $15,325. And that figure actually adjusts every 3 years, with the next adjustment set to take place on April 1st, 2016. And a bona fide dispute requires an objective basis for either a factual or a legal dispute as to the validity of the debt. Now, if the entity or individual has less than 12 creditors, the petition must be signed by at least 1 creditor who holds that same type of claim a non-contingent, undisputed, and unsecured claim, also in the amount of $15,325. If the petition is to be filed against a partnership, it could be commenced by either fewer than all of the general partners, or if all of the general partners in that partnership happen to be in bankruptcy themselves, by a general partner, the trustee of the general partner, or a holder of a claim against the partnership. Now, aside from who could commence the involuntary case, there are some limitations regarding against whom the involuntary petition could be filed. So, in essence, who may be an alleged debtor? Section 303 of the Bankruptcy Code, as we've indicated, governs involuntary cases, and particularly subsection A provides that the petition could be filed, quote, only against a person except a farmer, family farmer, or a corporation that is not a moneyed business or commercial corporation that may be a debtor under the chapter under which such case is commenced. This requires essentially two things. First, the debtor must be, quote, a person, and that includes both companies and individuals. And the alleged debtor must be eligible to be a debtor under the particular chapter which the case is being filed, which in an involuntary case, as we've indicated, would be either a Chapter 7 or a Chapter 11, and the differences between the two will be discussed shortly. From a practical perspective, the universe of parties against whom an involuntary case could be filed is relatively broad, but there are some exceptions. First, there are exceptions that are expressly identified in Section 303A of the Bankruptcy Code. So you have the farmer and the family farmer, although you don't hear much about involuntary cases being filed against farmers, at least not in this district. Then, as stated in Section 303, you have a corporation that is not a moneyed business or commercial corporation. And courts have generally construed that as referring to nonprofit organizations. And it's actually noteworthy that although an involuntary petition cannot be commenced against such nonprofits, they are permitted to file voluntary petitions. Now, other exceptions that are not explicit in the code against whom an involuntary petition cannot be filed include dissolved corporations. Those would be companies that have winded down under state law, as well as Dave mentioned earlier, individuals who have filed bankruptcy before and have been the subject of orders from a bankruptcy court restricting them from refiling a bankruptcy case.
Okay, although it's not an eligibility issue, there was something that interests me, and probably Asa as well, is does the means test apply to an individual who is forced into bankruptcy? And if you look at 707B1, which is the introduction to the B2 and B3 dismissal standards, it refers to a case filed by an individual debtor on this chapter. Unlike other sections of the code, it doesn't refer to a case filed against an individual debtor, so it appears just from the statute that a means test doesn't apply. And again, it's not eligibility. This would be something more subject to a dismissal motion, but it's interesting that that's the way 707B1 is worded. All right, so there are differences, as most bankruptcy practitioners will tell you, between Chapter 7 and Chapter 11. And one of the things that will need to be done before an involuntary petition is filed is deciding which chapter makes more sense for your particular case. In general, a Chapter 7 is always a liquidation, not reorganization chapter, and the entity is liquidated, its assets are marshaled and sold, and then in certain situations, for example, an individual case, exemptions may be paid, and you also may have liens that you have to deal with. So, before you file your involuntary petition, it's important that you do a little homework. You need to know whether or not there are liens. The best way to do that is to do a UCC search. Also, you may want to search the debtor's name in a title database within the at least several counties in the area that the debtor resides. Maybe you have a system at your firm that will give you a broader search base, but you definitely need to know what liens are out there against the property that you may be targeting for liquidation. And also, there are exemptions. In individual cases, an involuntary petition doesn't wipe out statutory exemptions provided under California law. So you need to know those exemptions and understand which ones could be claimed by an individual in the event he or she decides to elect certain exemptions. In Chapter 7, there is no discharge for an entity. So essentially, the company is put into bankruptcy. Its assets are sold, and then it is shut down, and it no longer exists for practical purposes, although it does exist. And in Chapter 7, there will be a trustee appointed, but that doesn't happen until after the order for relief is entered, unless the bankruptcy court orders one be entered before the order for relief, and we'll get into that a little bit more later. Also, the debtor remains in possession of the property that he or she or it owns prior to the entry of the order for relief, or in the event that a trustee is appointed before the order for relief, when that happens. So the debtor will be in possession, and that's important to remember in Chapter 7, because there could be a dissipation or secretion of assets before the entry of the order for relief, and assets could be lost, and you may not recover anything, and all your efforts are wasted in creating an involuntary case. In Chapter 7, once the trustee is appointed, certain things happen. First, the company will probably be shut down. At 9 out of 10 cases, probably more than that, where there is a Chapter 7 corporation that is operating, results in a closure of the company, because most cases are not treated as an operating case. And if there are actual cases debtors that could be operated to maintain a going concern, that operation usually lasts for a short period. Most cases it's 180 days. Sometimes it can be up to a year. Again, all the assets of the debtor will be marshaled and liquidated in Chapter 7. And then the trustee will be permitted to assume and assign, or if necessary, reject any existing unexpired leases or executory contracts. Although there are certain deadlines that come quickly in Chapter 7, and those deadlines are measured by the date the order for relief is entered. One of note is the 60-day window for assuming certain lease rights and contracts. Also, it is very likely where the trustee is appointed in an involuntary Chapter 7 that he or she will work with petitioning creditors to discover and liquidate assets of the debtor. And we'll discuss this in a little bit. There may be situations where you have a debtor who is put into an involuntary case and they refuse to prepare schedules and or assist with uncovering and disclosing assets. So that's Chapter 7 in a nutshell. Chapter 11 is different. It is a reorganization chapter, but sometimes that results in liquidation, where reorganization is not possible or not in the best interest of creditors. There is a discharge that will be entered if the debtor confirms a plan, and the plan calls for a discharge, which is generally always. And then also in Chapter 11, the corporation, if it's a corporation, will continue to operate, which is very important to the extent there is goodwill that's associated with the company. You may want to preserve that and avoid losing a valuable asset of the company that could be sold to another entity or individual. Also, in Chapter 11, the alleged debtor remains in possession and controls all accounts, and will continue to do so even after the order for relief is entered, unless the bankruptcy court orders the appointment of a trustee. So if you have an involuntary case, it's likely that you have a debtor who may not be working with your client and may not be trustworthy. So you keep that in mind, that it doesn't necessarily mean by filing an involuntary petition that the debtor turns over everything to a trustee. You need a trustee in the event that that's the situation, although a debtor in possession in Chapter 11 does have to report monthly to the U.S. Trustee's Office, and there is some governance by the U.S. Trustee's Office over the debtor's operations in bankruptcy. Also, the debtor will be permitted, just like Chapter 7, to assume and assign, or if necessary, reject certain leases and contracts. But there are different periods of time that are available in Chapter 11, and there's a little bit more time in Chapter 11 to make a decision on those unexpired leases and executory contracts. And in Chapter 11, the ultimate goal is always to confirm a Chapter 11 plan, but that plan will dictate how claims are paid, and we'll discuss this a little bit more in a few minutes, but it is very likely that the plan may actually pay less than 100% to your client. So you ought to try to figure out how a plan would look before deciding on which chapter you are going to file under. Also, during the gap period, as I noted earlier, a trustee can be appointed. When the gap period, again, is from the filing date of the involuntary petition to the entry of order for relief, should that happen. The standard for appointment of a trustee is different depending on the chapter that the case is filed under. A Chapter 7 trustee may appoint it if necessary to preserve the property of the estate or to prevent loss to the estate. That's found in 303G. It's basically irreparable injury to creditors if a trustee is not appointed, which seems to me to be a pretty high standard. Unlike Chapter 7, however, Chapter 11 requires the following. Appointment is in the best interest of creditors and other interests of the estate, and that's found in 1104A2. That seems to be a less stringent standard, and that might be something that you need to consider when you're deciding between Chapter 7 and Chapter 11, because you may want a trustee, and it may be easier to get a trustee in Chapter 11. Also, there's one other note that if a Chapter 7 trustee is appointed, which will happen at some point unless the case is dismissed, that trustee is not necessarily terminated from his or her appointment on the conversion of a case to Chapter 11. So that's something you ought to consider as well in deciding between Chapter 7 and Chapter 11. Okay, so now we briefly talked about the gap period, Asa. What exactly happens starting with the gap period moving forward?
Okay, well, just to reiterate, once the petition is filed, the case enters the period that's known as the gap period. And again, that's the period of time between the date the petition is filed and the date the court enters an order for relief, essentially saying that the bankruptcy case may proceed. And again, as indicated, the debtor is referred to as the alleged debtor during this gap period. And the period actually runs very much like a standard lawsuit. The petition would be akin to the complaint, essentially asking the court to declare that the company should be in bankruptcy. A summons is issued by the bankruptcy court naming the alleged debtor. The summons is issued shortly after the petition is filed. And again, like in a regular lawsuit, the petition and the summons then must be served on the debtor. The difference being here, as in bankruptcy in general, the petition and the summons actually could be served by mail. It need not be served via personal service. Once the petition and the summons are served, the alleged debtor then has 21 days to respond. And the response could come in three forms. It could be an answer to the petition, which is like a regular answer in a regular lawsuit, just admitting or denying the allegations in the complaint, most of which are already pre-filled into the petition form. It could also respond by filing a motion to dismiss the case under Rule 12b-6, or file some other Rule 12b type of response. Or it could actually file a voluntary bankruptcy petition or a motion to convert the involuntary case into a voluntary case, which essentially is the debtor or the alleged debtor consenting to being in bankruptcy. Now, once the pleading stage closes, the parties enter what, if it was in a regular lawsuit, would be called a sort of a discovery phase, discovery stage. And the general rules governing adversary proceedings in bankruptcy adversary proceedings generally apply to this phase. Discovery could be conducted, and evidence is gathered in preparation for what ultimately will be a bench trial to determine whether an order for relief should be entered against the debtor. And during that period, there are some pretrial remedies that could be pursued. With respect to the alleged debtor, it could ask the bankruptcy court to require the petitioning creditors to post a bond pending entry of an order for relief. And as for the petitioning creditors, as we have indicated, they could ask the court to appoint an interim trustee during this gap period. And again, if the need to have a trustee appointed is serious, for example, if there's some gross mismanagement that you're aware of, or some imminent threat of harm, and there needs to be a change in control of the debtor, then a motion to appoint an interim trustee should be filed concurrently with the petition. The next phase, which Dave will talk about, is after the discovery phase, is the prove-up and evidentiary hearing.
Okay, so as Asa had indicated, you conduct your discovery, you prepare for your prove-up evidentiary hearing, which in bankruptcy parlance is a trial. It's a short trial, but what the court needs to determine is whether or not this entity is in bankruptcy properly and meets a certain standard. The first thing to note is that the bankruptcy court is charged with conducting this hearing at the earliest practical time, and that's actually found in FRBP 1013, subsection A. So what that means is anybody's guess. Since you're putting a company through a bankruptcy case, it seems that that would be earlier rather than later so that you can avoid as much harm as possible to a company. As most of you likely know, bankruptcy isn't the best situation as far as credit, and is maybe you're going to lose vendors and customers where the company's in bankruptcy. So I think the intent here was to have these hearings early so that you could minimize damage in the event that the company is not found to be eligible for bankruptcy, or at least the creditors cannot meet their burden of proof. So at the trial, the alleged debtor, you need to prove as a petitioning creditor that the alleged debtor is not paying its debts as they become due unless such debts are in bona fide dispute, or within 120 days prior to the filing of the involuntary petition, a custodian, in other words, a receiver or potentially an ABC conducted by the debtor. In one of those situations, if that party took possession of substantially all of the debtor's property, then that would be the other way to prove that the debtor should be in an involuntary case. And the standard is found in 303H. The burden of proof at trial is on petitioning creditors, and the applicable date to determine whether or not the debtor was not able to make, or was not making rather, its payments on debts as they became due is the petition date. So it's important to note that, because if you put a company into bankruptcy or an individual into bankruptcy, and then they start making a bunch of payments to try to show that they are making their payments, that isn't going to be considered, or at least it shouldn't be considered by the bankruptcy court. What matters is what was going on prior to the petition date. And it's also noteworthy that petitioning creditors are not required to demonstrate to the bankruptcy court that administration of the case will be successful. In other words, that there will be a liquidation which results in a dividend to creditors. They only need to satisfy either the test that says that they're not making their payments on debts as they become due, or that there was a receiver or potentially an ABC initiated within 120 days prior to the filing of the petition. The showing that the debtor is not generally paying its debts requires more than just a general showing of the debtor's financial condition. And it can't just show that a few debts weren't paid. It's a significant showing that's required, and you're going to need to conduct a discovery to get this information so that you can prove up your case. Also, if you have a situation where it's just one creditor is not being paid, by the debtor, or the alleged debtor, that may also not qualify as sufficient grounds for the involuntary petition. The case might be dismissed. So you need to know before you get to trial how the debtor is doing with its vendors as far as payment. And if you have a situation where it's just one creditor, you may have a case dismissed, and as we'll talk about in a little while, that could result in attorney's fees, punitive damages, and so forth, which are ordered against you and or your client. Also, an evidentiary hearing that's conducted by the bankruptcy court is something that's usually decided by the court, and it's not really a jury trial. And the weight of authority indicates that this is a matter that's determined by the bankruptcy court. So let's say at that point you get your evidence in front of the court, and the court agrees and enters its order for relief, and the case then proceeds. After the case, the order for relief is entered, the cases really become, and I'm running the slide presentation, as you can see. Every time I talk, I manage to forget to go forward. But the case becomes essentially what it would be if there was a voluntary petition filed. The procedures, except for a few, for instance, the appointment of a trustee, run as they normally would. One thing to note is that the relation back date for purposes of clawbacks, whether it's an avoidance under 547 or 548, the measuring date is the petition date, and not the date the order for relief is entered, which is important because those dates could be very far apart, and you definitely want to make sure that you're not blowing any deadlines and that you are measuring the correct period of time for purposes of trying to claw back assets of the debtor. Also, once the order for relief is entered, the debtor is required to file schedules, and presumably the debtor will prepare those schedules and file them. If not, a trustee, if a trustee is appointed, can prepare the schedules and file them with the court. As far as your recovery as counsel for a creditor who has petitioned a company or individual into bankruptcy, you may be able to recover your fees and costs. There is a priority scheme that's found under 507A, and that petitioning parties, if their contribution to the case can show that it was substantial and it was a benefit to the estate, fees and costs may be allowed under 503B3, which is costs, and 503B4, which would be fees. Okay, so that's what happens after the order for relief is entered. There are pitfalls, however, and this is the part that all petitioning creditors need to be aware of. In the Ninth Circuit, unless bad faith exists, it's a four-part test in determining whether or not attorney's fees and costs should be awarded against a petitioning creditor for filing an involuntary petition if that petition is ultimately dismissed. The first part of the test is the merits of the petition itself. The bankruptcy court will look into that part. The second part is the role of any improper conduct of the alleged debtor. The third thing that will be considered is the reasonableness of actions of the petitioning creditors. And finally, the creditor's motivation and objectives in filing the involuntary petition. So it reads like a sliding scale test, and the court will be able to weigh these four factors to determine whether or not attorney's fees and costs should be awarded in a situation where there isn't bad faith. There is also a rebuttable presumption favoring the entry of awards and fees in the Ninth Circuit, and as one court has put it, a petitioning creditor should expect to pay the debtor's attorney's fees and costs if the petition is dismissed, which is a significant factor in deciding whether or not to file an involuntary petition. If you don't know much about a company or an individual's finances, you want to think twice about filing a petition, and it may make more sense to gather that information, if possible, during litigation in a state court, or perhaps through, if you're representing a lender, maybe there's an agreement that a debtor provides you with financial information. You ought to exercise your rights under the agreement to get that information so you know what your trial will look like on the order for relief. Also, as I noted earlier, in the event that the bankruptcy court orders the payment of attorney's fees and costs for the alleged debtor, the petitioning creditor's attorneys may also be liable. In addition to attorney's fees, the bankruptcy court has the power to enter a judgment against the petitioning creditors for actual damages caused that are approximately caused by the filing. And Section 303I2 authorizes the award of punitive damages even where actual damages are not awarded by the bankruptcy court. So you face the possibility of having a judgment entered against your clients for actual damages approximately caused by the filing, as well as punitive damages available under 303I2. So clearly, those two things alone, in addition to the possibility of owing attorney's fees and costs, are significant factors to weigh before initiating an involuntary petition. Also, the bankruptcy court may be able to award sanctions under 9011 depending on the circumstances. That's another factor to consider before filing an involuntary petition. So the takeaway from that is there's a very high level of due diligence that should be performed before you file an involuntary petition. And there are situations where it's likely that something is urgent and the petition needs to be filed to preserve an asset. And I think that would be something that you'd have to weigh against the possibility of having a judgment entered against your client for punitive damages and for actual damages, as well as an award of attorney's fees and costs in the event that the the involuntary petition is dismissed.
Another factor to consider in deciding whether or not to commence an involuntary case relates to considering whether putting the entity into a bankruptcy case will actually get your claim paid at all. One thing to understand is that a bankruptcy results in a collective or group type proceeding. It's not an individual collection proceeding. And what I mean by that is that whatever assets or money ultimately is made available to pay claims in the bankruptcy case will be shared with all of the debtor's creditors. So if it turns out in the end that there's not enough money to go around to pay all claims, you will only receive a pro rata share of the assets, which could mean receiving pennies on the dollar, sometimes if that at all. And payments are made according to a priority scheme that's set in the bankruptcy code. And if you only hold an unsecured claim, which would be the case if you're one of the creditors that commenced the bankruptcy case in the first place, you won't receive any payment on your claim until various other higher priority claims are paid in full first. And those type of higher priority claims include fees that are paid to the bankruptcy trustee pursuant to the bankruptcy code, and fees and costs that would be due to the trustee's professionals. So, for example, the trustee's attorneys, accountants, and other professionals the trustee may hire in the course of the bankruptcy case. So you really need to take this into consideration before spending what could be a lot of time and money commencing and prosecuting the involuntary petition to an order for relief, only to discover in the end that you won't get paid on your claim at all, or very little of it.
Worse yet, there's this possibility that you have a situation where your client may have received a preference, which would have been a payment of either a payment made within 90 days if they're not an insider, or if your client is an insider, potentially something paid to your client within a 1-year period preceding the filing of the involuntary petition. And the reason this is important, and it came to my attention, was this actually happened in a case where I represented a trustee. The petitioning creditors, 2 of the 3, had actually received very large preferential payments. Both payments exceeded, on the aggregate, more than $100,000, and both of those creditors ended up being sued by the trustee and had to settle out with the trustee for a large sum. And during the very beginning part of that litigation, the adversary proceeding, the lawyer representing the petitioning creditors was relieved of his duties, and I hope sincerely that he doesn't have a malpractice issue on his hands, considering what happened.
Right. So if at all possible, if you did receive a payment before you file the bankruptcy case, or before you start thinking about filing an involuntary case, you may want to, if possible, let the 90 days pass from the date you received the payment before actually commencing the case. The final thing we wanted to discuss were just a couple of scenarios under which we think an involuntary bankruptcy petition should be considered. I think on the slide we have 3 general situations in which it should be considered. The first one is to preserve assets, and this is where, when the debtor or the entity you want to put into a bankruptcy case is at risk of losing what could be a valuable asset that could be monetized or otherwise used to pay your claim. You could use an involuntary petition to try to preserve that asset. So, for example, suppose an entity that owes you money, or your client money, is a tenant under a very valuable lease. The lease, for example, could either be under market, or it may have a valuable option to purchase the underlying real property. In bankruptcy, as we've indicated before, the debtor or the trustee would have the ability to assume that lease and exercise the purchase option, or it could assume and assign the lease to a buyer for money. And this could, has the potential of bringing substantial funds to the estate if it's a valuable piece of property, or, again, under market lease. But assumption and assignment of the lease could only happen if the lease exists and is in effect at the time of the bankruptcy filing. If the lease is terminated before the case is filed, filing bankruptcy really won't help to preserve that lease. The lease already would have been lost by the time you file bankruptcy. So if you learn that the tenant, which is the individual or entity that owes you the money, is about to default under the lease or has defaulted and is on the verge of losing the lease, and you learn that the tenant really isn't doing anything about it or not planning to do anything about it to maintain the lease, that would be a good time to consider commencing the involuntary petition in the hope of preserving the lease. And so long as you file bankruptcy before the lease terminates, you ensure that the lease is preserved and made available to potentially monetize, to bring money into the estate to hopefully pay your claim.
Probably the most common situation is a petitioning creditor wanting to have a debtor's assets liquidated, where those assets have significant value to creditors. I was appointed in an involuntary case for an entity called Great Con. What they sold is, well, the fast food company with 19 or 20 locations in different malls. You put raw vegetables in a bowl, you hand it over to the cook, and the cook makes the vegetables with noodles, and for a good $6, $7, you have a very, very tasty meal. Well, what happened was the principal of the company decided that he didn't want to be married any longer. He moved on to Vegas with his girlfriend and left the company, left it behind to die on the vine. And part of that motivation for leaving town was a creditor had a $1.2 million judgment against the company. So with the help of my counsel and with some field agents, we were able to locate all the entities that were franchisees, to locate trademarks, and to take all of the rights that the debtor had and package them in a deal. And we sold everything to another company, and that creditor, who didn't, by the way, know a whole lot about the company, didn't know anything about the assets, didn't know anything about the company's liabilities, they're going to receive probably about 40% of what was awarded to them, which is a significant amount of money, and it's unclear whether or not they would have recovered that if they'd done all this on their own. Another situation is where you have an entity that may have significant assets and the person in control may be the problem. So for instance, you have a CEO of a corporation who is just refusing to play ball and to pay up on a judgment or to pay some open debt. And so filing the involuntary petition and immediately seeking the appointment of a trustee could help fix that problem, because the CEO, in my example, would be taken out of control, and the trustee would take over all the finances and assets of the company. Or if the trustee isn't appointed, at least that individual now has some reporting duties. They are treated as a debtor in possession, at least in Chapter 11, and need to report to the U.S. Trustee's Office, who would then have oversight over the finances and also the assets of the company, which would probably make it easier for a company to get paid so that these assets aren't secreted or lost. And then finally, there's a situation potentially where a valuable asset is about to be foreclosed, and the debtor seems unwilling to do anything about the foreclosure. A foreclosure obviously could be stopped if an involuntary petition is filed, because the automatic stay will be automatically triggered by the filing of the involuntary petition, and at a minimum you can buy some time to avoid that foreclosure, potentially work out a deal, whether it's with or without the debtor's help. Perhaps you have a trustee appointed, and have the property or the asset sold before it is lost at a foreclosure sale, which could end up yielding far less to your client, who is a creditor. So that basically sums up the hypotheticals, and now we're going to open up the floor to any questions. Okay, we have one question here. So the question is, what happens if the debtor refuses to prepare and file schedules? And that's a tough question to answer. The short answer would be that the bankruptcy court, once the debtor has been, or the order for relief has been entered, can enforce its powers under 541 and 105 and order that these schedules be filed and hopefully use its contempt powers to coerce a debtor to comply with preparing and filing its schedules. That's the short answer. There could probably be other ways to do it. I think if you had a trustee involved, a 2004 exam might be helpful, and perhaps you have individuals who will voluntarily help prepare those schedules if you have a trustee in place. But that's a tough question to answer.
I'm seeing here another question. How can creditors get information required to ensure the proper filing, but before filing the involuntary, to avoid a risk of being hit with attorney's fees or punitive damages? In that case, the best way, for example, would be if you hold a judgment against the alleged debtor, or what will be the alleged debtor, in which case you have the option of conducting some pre-filing discovery through, for example, a judgment debtor exam. That would be the ideal way. You could get some information that could ultimately help in satisfying the requirements, or making sure you have the requirements satisfied to commence the involuntary and not risk it being dismissed. If you don't have a judgment against the debtor, another way could be just sort of informally conducting some type of investigation of sorts by talking to other creditors if you're aware of them. If it's in a particular industry, you may know the other players, you may know other vendors if you're a vendor, and the best thing would be to try to reach out to them and just to get some more information. They may have some more inside information that could give you, allow you to make a more informed decision as to whether or not you'd ultimately be able to satisfy the requirements to make sure you don't get hit with attorney's fees or damages.
Okay, it looks like we don't have any more questions. So with that said, we're going to end today's seminar. We thank you all for joining us today and appreciate you jumping on the call. I know it's the middle of the day.
And if you have any questions or need some specific information or want to discuss any particulars, please feel free to reach out to either David Goodrich or me. This is Asa. And our contact information is included in the materials on the last slide.
Okay, thank you all.